forward to this computer. All right. Sam, the floor is yours.
Perfect. So welcome everyone to this AI and privacy masterclass session about whether the algorithm can say no. And this session is important because we're not talking about hypotheticals or theory anymore. We're talking about what's already happening. Because here's the thing, AI is already regulated all over the world. And not by some distant AI acts, but by laws that we already know, including GDPR and the California Consumer Protection Act, also known as the CCPA. Katrina, if you will change. And the language that these regulations use might not be AI, but these rules still absolutely do apply. And so, without further ado, today I will walk you through how the GDPR and CCPA already regulate AI and profiling, what counts as automated decision-making under both regulations, the real questions our clients and clients all over the world are asking, and also how to future-proof your governance without waiting for AI-specific laws. And so the first thing to consider is how both regimes define and deal with automated decisions. So in GDPR, it's regulated under Article 22, which gives individuals a right to not be subject to decisions made only by automated decision processes. If we just stay there for a moment. And this only applies when the outcome is legally or similarly significant. So think credit approvals, hiring processes, loan rejections. These are situations that go under automated processing. But here's the kicker. Human involvement must be meaningful under GDPR and not just a rubber stamp. Now, under CCPA and the new Automated Decision-Making Rules, or the ADMT, California has taken a broader approach, namely opt-out rights that apply to automated decision-making technology. For those that don't mean what opt-out means, it's what it sounds like, namely that you can say no to being involved in an automated decision-making process. And that applies to areas such as employment, credit, and housing. And even partially automated decisions can trigger these obligations, unlike the GDPR. And so disclosure duties also kick in. So not just what you do, but how. And so the main takeaway here is that California casts a wider net than the GDPR at the moment, because it also covers partially automated decisions. So surface level reviews are no longer enough. If there's a logic involved that affects people's lives, then you are in the zone. Now, when it comes to profiling, this is where the rubber hits the road. It's not just a buzzword. Profiling is actually a legal trigger, and quite a sensitive one. And under GDPR Article 44, it's defined as any automated process that evaluates personal aspects. And that means, credit scoring, predictions, analyzing someone's behavior, all that counts as profiling. Now, the CCPA's ADMT definition goes even further than GDPR. It says any technology used to evaluate, predict, or influence behavior. And what does that mean in practice? It means that both frameworks see profiling as the gateway to AI regulation. So if you are profiling, then the risk obligations will follow. Now, when it comes to risk DPIAs and audits, this is a very important part. Under GDPR, if you are using AI to significantly impact other people, which includes AI, of course, then a data protection impact assessment, colloquially known as a DPIA, is required. For instance, if there is black box logic, then that is a red flag. And this isn't optional because data protection authorities, or DPAs, are already asking tough questions and sometimes even penalizing if there is non-compliance. Now, under the CCPA, then certain thresholds need to be met. If you're processing data on more than 250,000 Californian consumers annually, or 50,000 sensitive records, or you're deriving 50% of revenue from sales of personal information, then you are in annual audit territory. And here's the catch. ADMT rules in California apply early, even at the design stage, and opt-outs are enforced, and quite strictly so. So non-compliance is not a soft landing. And so the bottom line here is that governance is expected now, which means that organizations must stay proactive. Now, we've had a lot of questions about this lately, and so we have many different organizations. And these questions are not academic, they are practical. So clients are already asking, if we are using AI to hire, do we need a DPIA? The question is yes, because hiring decisions class as high risk under GDPR, and therefore a DPIA is required because this is a process that significantly impacts people's rights and freedoms. Whereas under the CCPA, it may also apply if AI scoring is used for scoring or filtering candidates. If it's AI assisted, then does Article 22 still apply? Now, let's remember that Article 22 applies to automated processes. So if it's AI assistant, then Article 22 doesn't apply if meaningful human involvement exists. However, the human must also review and influence the outcome, not just rubber stamp it for it to be not classed as fully automated. Are product recommendations ADMT in California? Usually no, unless it's tied to access or pricing or credits, jobs and housing, etc. Whereas pure marketing is generally out of scope for this law. And finally, do I need a privacy notice for machine scoring? The answer is yes. And in the privacy notice, you need to have a section specifically designated for this that explains that profiling is used, if it is used, the logic behind the profiling, and the potential impact on the individuals. And these questions are real and they are happening right now. So if clients are unsure, we need to step in before regulators do. Now, when it comes to your privacy toolbox, here is the good news. You don't need to reinvent the wheel for your compliance program. You just need to adapt what you currently have. So that means reusing what you already have in your toolbox, including DPIAs. If you have DPIAs, then use them to vet AI logic and fairness. If you have data subject access requests processes, then extend those processes to also cover ADMT access rights. If you already have a privacy notice, really good, then just add a plain language explanation section about the AI logic and its impacts. So AI doesn't demand a new playbook, it just demands a smarter application of the ones you already have. Now, it is important, though, to remember that governance starts before regulation. And that's a final word before I wrap up my part. So if you're waiting for the EU AI Act to solve your compliance issues, then regrettably, you're already behind. If your organization is using scoring tools, recommendation engines, or it's using AI in recruitment, credit scores, or customer journey mapping, then you're already in AI territory. So governance cannot start with a law, it starts with recognizing the risk and the responsibility. Now, the key takeaways here to remember is that profiling is a trigger under both GDPR and the Californian CCPA. Semi-automated automated decisions will still count, so compliance will still apply. Data protection impact assessments and opt-out mechanisms are your safety net. AI governance is not coming, it's already here, and it should be treated as such. So it's important that you understand the law and then embed the law into your product design. Because when the algorithm says no, The regulators will ask why. It is therefore important to make sure that clients have the right answers today. That was my part of the presentation, and with that I shall yield the floor to my colleague, Katerina.
I unmuted myself. So yeah, sorry about that. Um, okay. Sam wrapped up. Now, if I can just kindly ask Nicholas if you can switch off the video because this is being recorded for so that we don't have to adjust later on. Thank you very much, Nicholas. Okay. Now I'm going to share my presentation. Okay. Mhm. Just a second. Uh, okay. I presume that now you can see. Sorry about the little technological hiccups. Welcome all of you on this super interesting topic, which is about can the algorithm say no, mostly about the AI and privacy, but my part will tackle the AI governance part. So, can the algorithm say no? Uh, Now we'll dive into it. Oh, okay. I just came back, still a bit jet lag, from the US, where I was a speaker on the AI summit, and AI governance and compliance was the topic. And it is not anymore just like some distant shall we or shall we not, but AI governance and compliance has become the cornerstone for successful companies to implement and govern AI because AI cannot be trusted without governance, and neither can we. That is a really bold statement, but it is also very true. Why this matters now? So AI is already, as Sam, my colleague, mentioned, is already influencing who gets hired, who gets credit, who gets access to care. And the regulation is catching up fast. But the question is no longer if, but the question is how. Of course, on one side, we have the so fast, super fast growing technology, which is beyond powerful. So we also got into something, the AI tools and the AI development itself, the large language models, the Gen AI and everything, which is developing much faster than the legislation can keep up, of course, because the legislation and the legal part is slower to move. But now we came into the situation where the catching up of the legislation is actually and governance is actually helping the companies to grow faster. Why? Because implementing governance into their company and risk management, because AI risk assessment management is also one part of the enterprise risk assessment. And if it's not, it definitely should be. The biggest players from the Fortune 500 have already implemented like very strong and very compliant governance plans, not so much to be, to adhere to the law, but more so to be able to grow faster and in a more stable way. So once the businesses and the companies recognized that the having governance policies in place will help them actually be more profitable, now everybody is on the governance and compliance train. Oh, okay. The shift. So from AI as a tool, we went to the AI as a regulated decision maker. So now governments are no longer asking what AI can do. They are asking, of course, the legal part, who is accountable when it does it? So, as we all know, and if you are lawyers yourself, or if you work in compliance and some sort of cybersecurity, you know that the one of the most often questions that we get asked is like, "Oh, if I drive like the car who is self-driven car and it crashes, who's gonna be responsible for the accident?" So we all probably got these questions, and of course it cannot be. It's always the human, the one who is responsible, as we all know from law that there is this objective responsibility, even if it's not the human, or objective liability, even if the human wasn't even close. If the human was the one who pressed, the yes on the control button of the self-driving car, then of course the responsibility is of that human or of that company. Of course, it depends in the details. Okay, so now we have the beautiful EU AI Act. Why do I say that? Because the EU AI Act can be, I don't know how many of you read it. I read it many times, and I found it very, very useful for every person, for every legal officer, of course, in a company which is using or deploying AI. Because it gives you a sort of a framework on how governance should look like. I also made the question about the EU AI Act in the US, and it was very interesting to hear the answer. So my question was, okay, you are saying that it's a general prejudice that EU is over-regulating, that it's stopping innovation, that it's stopping research, that it's stopping like companies making profit. And I made the question on the summit if anybody from the public read the EU AI Act. I was surprised to see that 5 people raised their hands. So, like 5 people, which I thought it's a lot to read the whole act. And I asked them, did you find anything in the EU AI Act which stops research, which stops innovation, which does not allow free deployment or usage of AI? The answer was no. So the EU AI Act does not even tackle research and innovation. It just bans some AI tools which are which are put under the unacceptable risk. So unacceptable risk, this is like social scorings, the AI that exploits vulnerabilities of specific groups, real-time remote biometric identification. So this type of services should not be allowed by an ethic company, neither if it wasn't, banned by the AI, because it's obviously not in line with the ethics and with the with the policies of companies who do care about their own image and about their own how they treat their customers and consumers. So we have under the EU AI Act is a risk-based framework, and we have 4 levels of risks. There is the first one, which I just mentioned, which are banned. There is high risk, and we talked about high risk. We mentioned three things before. I'll just gonna go back, and those things are high risk. So when the AI tools are managing or sort of deciding or having a saying or screening on who gets hired, who gets credit, and who gets access to care, uh, these risks are considered to be high risks, and those are put under strict obligations. One of them is the obligation of AI literacy, so that the staff is highly educated about these tools and about the governance of the tools. And also the strict obligation is human oversight. So it all, of course, depends on the tools that they are using, but the risk assessment is one of the things which should be done first. Limited risk requires transparency. So this here we are talking about chatbots. Like if a human is communicating with a chatbot, this should be clearly and loudly said, like now you're talking with a chatbot, not with a human, because elderly people, maybe even some younger people, could be easily confused and they could like misunderstand that the conversation was made with a human, whereas it was made with a machine, with an AI bot. There are minimal risks, so there are no new duties. And most of the AI tools, I think somewhere I read around 90%, are put under a minimal risk, where we don't have any obligations, like any limits, how to say, uh, to observe. So focus is impact is on humans, not on tech. And the most used word in the EU AI Act is human oversight. So that means that the humans should always have the last saying when it comes to this high risk and some limited risk technologies, AI technologies. So what is high risk AI? So we already mentioned and went back on the second slide, but now I will repeat that high risk AI is the AI systems that affect real lives. So what fields are those? Employment and hiring. HRs from all over the world have already, like some time ago, when they started to be compliant and to adhere to the requirements of the EU AI Act, because employment and hiring is a sector where AI tools are used a lot. Therefore, they need to have the special like tools and policies on how they use these AI tools on when hiring, when screening the CVs, when employing. So the machine cannot have the last saying on on the questions which are very sensitive. So it has to be overseen by humans for the final decisions. Then we have, of course, credit and financial access, insurance and healthcare, and of course, always is a sensitive topic, education and public services. If it affects people's futures, then it's high risk. High risk obligations, although I already mentioned some things, but now let's go and let's list them all. So, high risk obligations under EU law, EU AI Act, which is a regulation directly applicable across EU countries, but is also applicable, as you know, for all companies who have even one customer from the EU. So required for five high-risk AI systems is to risk management and testing, high-quality data sets, bias mitigation, human oversight mechanisms, documentation and traceability. So although this documentation, when you say to companies, they go like, oh, more papers, more policies. Um, this, like, it's not maybe the most interesting thing at the beginning, but this is something to have in place, like the policies and the documents needed under EU AI Act and under AI governance in general, are the papers that are gonna make the future, but also the control and the growth of the company much more stable and much more in control, of course. Because once AI governance has become the cornerstone for faster growth, then the company said, "Oh, cool! That is not that bad. Let's put that in place." Why is it the cornerstone for growth? It's because it gives security and it gives clarity, and other companies faster, for example, buy smaller companies, AI companies, if they have these AI governance documents in place, if they have already done all these papers, because then doing the due diligence is so much easier. Well, then, if this doesn't inspire or, how to say, make companies adhere to the EU AI Act, so if you don't go by the carrot, or how they say, then there are penalties. They have not yet been applied, of course, because not all the parts of EU AI Act are in force yet. But the penalties for not being compliant are very, very high. So the 15 million euros or 3% turnover for non-compliance. So if you're earning less than, if 15 million is less than your 3% turnover, then they're going to apply 3%. For huge companies, this is like a lot. Or 35 million or 70%, whichever it comes first for the company in question, will be charged with that, will be fined with that amount. Okay, now we will briefly cover a law which is not yet, it's not yet in force. It will be from the beginning of 2026. And California ADMT, and what does it cover? Automated decision-making technology. So they decided to call it like this. AI that replaces or assists human judgment in employment, credit and housing, education, and healthcare. Do you see the similarity? So they call it a bit different, but they cover exactly the same things as the EU AI Act. Even if partially automated, these decisions, automated decisions from machines, are covered by the Californian Act. Risk assessments are mandatory. Risk assessments for AI tools should be part of the ERMs, which are the Enterprise Risk Assessment Management, and all the companies, especially like the newest news from the US, they are already putting the AI risk assessments under their general enterprise risk assessment. So significant AI use requires a privacy risk assessment balancing business goals. So we should, like, there are some laws which are, there is something in the chat. I will check later. Because now, when it comes to law, the law should always protect the higher good, right? I'm sorry, I'm just gonna have some water. So of course, for companies, the highest goal, highest good is to make profit, but we as humans have other goods which have to be protected, and those are our privacy against bias and fairness concerns. So we should put these two sets of rights in some sort of balance. Well, it's not some sort, it's legally a required balance. So we didn't consider the impact is no longer defensible. So privacy risk assessments and when it comes to a significant use of AI are mandatory. Global direction of travel, different routes, same destination. Okay, so I will just put in perspective worldwide how the legislation regarding AI is set globally. So in EU, we have risk-based and enforceable. In US, on state level, rights and transparency. They still don't have a federal act, and the states, US states, have signed a petition, or I don't know how they exactly call it, in the US, that they would like to have a like a federal act which governs AI, but still not official. Until that happens, probably each state will regulate for itself, which can make, of course, legal confusion, and the businesses will not be happy with that. So probably business growth and business security and transparency will push for a more a more unique, more harmonized legislation statewide. Okay, I'm just going to admit, yeah. So in Canada and Brazil, AI bills are incoming. In Singapore is voluntary governance plus audits, and AI governance is no longer optional. The strategic reality. AI governance is not just legal, is not just technical. It's a boardroom issue, a trust signal, and a business enabler. You see, it had to become that in order to become important, because uh, otherwise, companies at the beginning were not so much into regulations, governance, laws, and stuff until they saw that actually that is going to help them boost the profits, because putting everything into a framework and knowing what they're doing when it comes to AI and AI implementation and governance are going to help them grow faster, is going to help them grow faster. And of course, they now want to do that in the best possible way. Companies with good governance deploy AI faster and safer. Why? AI is not a magic tool. It's not some magic which you just like put there and it's going to work itself. Especially for companies, for systems where is more than one user, although even if it's just like a couple of employees, it is best and it's absolutely advisable, as I always say to my clients as well, to have in place AI governance plans and papers and documents, because that way, not just to adhere to some EU regulation, but to grow faster and safer. Okay. Key takeaways. I hope so. We have like the newest and the freshest news from the whole world. And those can be summed up like this. AI decision making is already under regulation. We saw California, we saw EU AI Act, we saw the whole world is following those steps. In my opinion, this should and will probably not because of being a letter, a legislation which doesn't serve anything. When it will become obvious that having an AI governance is in place, even more obvious that this will help companies grow and faster and make more profit. Well, there will be like they will be deploying even faster the governance plans. And AI governance specialists and people educated in these fields will be the most sought out experts. High impact means high accountability. Obviously, the more responsibility, the more accountability. Human oversight and transparency are essential, and start governance now, not later, because it is easier to go little by little than like deploy everything without any guidelines, without any policies, and then in a company of, I don't know, 500 people, you don't know if I don't know, Susan is using chat GPT or Claude, or what are the policies when it comes to having the outcomes and outputs from that company outside. All these things should be regulated internally with papers and documentation which govern the use, even if of something banal, which everybody is using now, like the Gen AI tools. Uh, okay. What is missing? Most firms still lack clear AI inventory. What does that mean? Clear. I was talking about this, and companies and representative of the companies were so interested in this part. Clear AI inventory. You should know all the within the company, of course, all the AI tools that are used, internal ownership structures. So who is which part of the company which is responsible for what tools, audit ready documentation, cross-functional governance workflows. Without this, compliance is just a theory. Okay, I will stop here and we'll invite Sam back for the most interesting part, which is the Q&A. And we are happy to answer your questions. I will just stop sharing. Okay.
Thank you very much, Katerina. That was a brilliant presentation and very enlightening for myself as well, who's mainly involved in the legal aspect. And I do believe we gave our viewers a very holistic view here of AI and privacy. So any questions that you might have, just drop them in the chat, and me and Katerina will be more than happy to respond to them.
Yeah. If we know, because all these things are still okay. Oh, you cannot see, Sam. Do you see the questions when I put them up like this or
Yeah,
not?
yeah.
Yeah.
We actually
Okay.
just received a question now, which says, are
Okay.
there frameworks that procurement can use for third-party due diligence? Please do clarify that question. When
Yeah.
you say frameworks, are you referring to laws, or what is it you're referring to specifically here?
Guidelines.
Because I would say GDPR definitely does regulate third-party due diligence. Obviously, you do need a data protection, data processing agreement in place that regulates how your vendor can process your data and who bears the responsibility if anything goes wrong, and what they can and cannot do without your your permission, of course, as the data controller. And whereas in the CCPA, it's slightly different. It's not as regulated as in the GDPR, but you mainly do need to specify in the agreement that the data is not to be sold, because they are very clear on that. The do not sell my data.
So now I'm thinking of like, are there frameworks that procurement can use for third-party due diligence? So when you say procurement, Caroline, you probably refer to procurement of the company in for
Hi, sorry,
procurement.
can I
Yeah,
unmute?
yeah, please
Sorry,
do. Yeah,
apologies.
no
Sorry.
problem.
It's a vague question because I think it's a vague problem at the moment.
Yeah.
So if when you're buying, most AI that people are using is purchased through, it's very seldom
Yes.
developed out of house, and there's layers of it, and there's architecture, there's technical architecture to the systems which are poorly understood. But if I go to a company that says to me, you can automate your call center, and we'll get bots that will answer your customer questions, and I want to purchase that system. Just wondering, is there so for your supply chain risk or your third party risk management, what would you recommend? I don't know if you've got this far with it yet, but what would you recommend companies use? You have to go to procurement and say to them, look, before anyone is allowed to implement a tool, we need to make sure of these three things. So like, for example, when I assess systems providers, I look for very basic things like, do you have a privacy policy? Do the terms of reference talk about your AI practices? There's things like that. And I found that a lot of these tech companies don't even have those basic documents. Showing a level of immaturity in the organization that is quite worrying. And I don't know how much of their system they've actually built and understand, and how much they've leveraged other layers of AI, borrowed other applications and APIs that they themselves haven't interrogated or tested. So for example, I know the AI law talks about the testing. You have to make sure that your models are providing responses in the way you expect them to provide responses.
Yeah, this is such, yeah, sorry, go on.
Yeah, sorry. And when I actually recently attended an AI expo, and I asked this question, like, how do you test, how do you validate the responses of your AI model or of your AI system? And they really looked at me they didn't know what I was talking about.
Oh my God.
So how do we,
Okay.
as a corporate, how do we protect ourselves to make sure we ask these people questions?
Okay, Caroline, I don't know your background, if it's legal or if it's more like procurement, but there are basically, from what I've seen, companies have started putting clauses in their procurement contracts with the third parties, where they, in a way, if they don't agree, then of course it's a clause, both parties need to agree, but where they shift the responsibility of the functionality of the tool to the vendor, because the company itself needs to have some guarantees. So if you're buying, let's say, this call center automation, the company from which you are buying this AI tool or the complete like product, so to say, needs to give you the guarantees that they have adhered to the all the legal requirements when it comes to AI laws or privacy laws, because otherwise it's best to look for a company which did do that, because this is what we are actually even that we are talking about. So the companies which will not put these frameworks into place will lose customers, because obviously if you went to that third party provider and they were like, we don't know, you're going to try to find someone else who's going to say, look, this is like the way we work. These are the laws that you need to, that are respected by our product. And we guarantee that when it comes to our part, we got you covered. And then also, I don't know from which company or institution you are from, but the company itself should have some frameworks in place on which type of AI systems, on how high will the standards be to deploy a certain AI tool or AI product, like this one for the call centers, for example. Hope this answers the question,
I can
Caroline.
also
Yeah.
chime in on what you said, Katerina.
Yeah,
So,
sure.
having those sort of frameworks is really important. Some of them are, for instance, NIST cybersecurity framework, which is a gold standard in both the US and the EU, and also the ISO.
ISO, yeah.
Yeah, widely used access vendor controls. Basically adds a layer of privacy, making it useful for both GDPR and CCPA alignment assessments. And also shared assessment SIG questionnaire is also popular for structured deep dives. I would also say that for privacy, as I mentioned earlier, many organizations use custom vendor assessment templates, so data processing agreements, based on Article 1028 of GDPR, which covers data categories, processing purposes, and transfer mechanisms, and also security measures. If there is a higher risk processing, then vendors may ask to contribute to complete a data protection impact assessment, which may complete their DPA agreement. And as for AI tools, and you're welcome to correct me here, Katerina, the AI Act and NIST AI Risk Management Framework are emerging references. Procurement can ask vendors to classify tools by risk level, and also provide documentation on explainability, and also on bias mitigation and human oversight. So I would say that a risk-based tiered approach works best. Lighter checks on for low risk vendors, including a DPA agreement, and more intensive due diligence, including on the legal privacy and technical reviews for high risk or ADM vendors. Does that answer your question?
Yeah, thank you. Yeah, the ISO, so just to answer your question, I'm in compliance, and so part of my job spec is to help my customers to navigate the actual risk of the tools they're leveraging. So I'm always looking for the framework, but in my mind, there's no point using a framework if nobody knows what it is or nobody understands it. So ISO is an obvious one because most of EU seems to understand ISO.
Yeah.
But it's it's difficult to I think there are going to be tools coming out of the EU as well to help with this kind of assessment. But I'm just wondering if there's something that AI tech startups can use now to get badges or something that they can leverage that will communicate that they are in fact being responsible. And
definitely, clauses. You need to put clauses in the procurement contracts which protect you, which do not make you liable if the vendor is not compliant. So you transfer the liability to the vendor who is selling you a product which should be according to standards like ISO, and NIST, and other ones. Even OECD is now making another like a standardization for services. These things, when they are just like coming up, these questions, and of course the solution will be probably in a way uniformed, because it has to be, because you cannot like it will make the business easier, and Yeah.
Thank you. Thank you very
Yeah.
much.
You're
Thanks,
welcome.
Caroline, for your question. If anyone else has a question, we're more than happy to answer it.
Yeah, we have Nicholas. He asked, how can an organization demonstrate meaningful human oversight in AI systems used, for example, in hiring or credit decisions? Can you see it, Sam?
Yeah, I can see it.
Okay, so this is a super interesting question and very concrete. How is meaningful human oversight proved in AI systems used? That's why exactly you need to have these documents, these AI usage policies within the company where it says, for example, I don't know, CVs, for example, will be screened for like, I don't know, in this way. And this person, you need to have a responsible person after each procedure is, so let's put it this way. Maybe it will be easier to explain. In a situation when the problem occurs, let's say somebody's used the company because on the basis of discrimination, and they say no, there was like I don't know, probably I was discriminated because I don't know, my age or my nationality or something like that. And then they will not ask like for the car driving, they will not say that the AI tool is responsible, but the person who operated these tools will be responsible in case of a problem. Therefore, there needs to be a roadmap, a framework on how this responsibility line goes and who are the people, actual real people who are doing the human oversight over these procedures. They will be doing this thing in a correct manner, because otherwise, if something goes wrong, they will be the ones who are going to be responsible. Because, well, I don't know if this answers your question, Nicholas, and if you, Sam, have anything to add.
Yeah, a really good answer. I could build on it a bit. So human review before final decision, that's a very important part to show that there is human involvement, so that the candidate can possibly challenge, correct, or maybe even reject the decision. So if there's a loan denied by an algorithm, then human review's applicant data can be overturned. If staff are trained and empowered, that's also a really good way to show human involvement. So that they're not just following scripts, they're actually making independent judgments. And as Katerina said, documented review procedures have policies in place that explain when and how human review occurs, and also have audit trails and logs that show decisions that were actually reviewed and not just auto-approved. And also have accessible challenge mechanisms for individuals. So if there was an automated decision, then people need to be able to contest them and request human involvement, and it can work in practice. So, and also ongoing system monitoring. So the human monitor needs to monitor the system's output over time and also detect any bias, errors, or anomalies. And the result trigger models need to be updated, and policy changes need to be implemented regularly whenever needed.
Thank you. Thank you so much to both.
No worries,
You're
Nicholas.
welcome, Nicholas.
I do believe, unfortunately, that we've run out of time, Katerina,
Yeah.
but really
Yeah.
brilliant questions. And we've answered all of your questions. There are also going to be package offers coming up, so stay tuned on those. And we will be seeing you again soon.
Thank you. Thank you, Sam. And thank you, everyone, for joining. And yeah, we are preparing something that you do not want to miss because this, like when we just say, like, we will put in place the concrete documents and policies which you can use and adapt to your companies, and then to have like a non so abstract like feeling of what is actually necessary and what other companies are using and deploying, and to make your life so much easier. So thank you all for joining once again. Have a great afternoon. Here in Europe is afternoon, and see you again soon.
Thank you. Goodbye.
Ciao. Bye. Bye bye.